Exam Scholar, Real Estate Edition.
Question 1. Which of the following items could not be used by the owner of a hardware store as security for a loan, under the provisions of the Uniform Commercial Code? A. A personal note endorsed by him. B. Accounts receivable. C. Stock for sale. D. Equipment and fixtures. Answer. C. As the stock will be sold, it cannot be used to secure a loan. Question 2. A valid escrow requires which of the following? A. Escrow instructions with no conditions. B. A binding contract between the buyer and seller and the conditional delivery of transfer instruments to a third party. C. The services of a licensed real estate broker. D. None of the above. Answer.
B. A binding contract between the buyer and seller and the conditional delivery of transfer instruments to a third party are required for a valid escrow.
Question 3. If the loan-to-value ratio is low. A. The equity in property is high. B. The equity is not affected. C. The equity in the property is low. D. None of the above. Answer. A. Loan-to-value ratio is the ratio of the loan to the appraised value. If a 90% loan-to-value ratio is given by a lender, that indicates a 10% down payment, and a beginning equity of 10%. If the loan-to-value ratio is only 60%, the down payment is 40% and the beginning equity is 40%. The lower the loan, the higher the equity. Question 4. Sellers are usually reluctant to cancel an existing transferable fire insurance policy in the event of a cash sale, due to the fact that A. A buyer may not properly cover the property. B. A higher short-term cancellation rate will apply. C. It could result in cancellation of other policies. D. The elimination of a cash return in the proration. Answer. B. A seller on a cash sale would be reluctant to cancel an existing transferable fire insurance policy because the seller would receive a short-term cancellation rate. Therefore, the seller would prefer to transfer the existing policy to the buyer. Question 5. A minority purchaser enters your office and states they are looking for, and interested in purchasing, a particular property in a minority neighborhood. You could legally assume that A. This person is testing you and your legal procedures. B. They are interested in that particular property. C. They are interested in owning a home in an all-minority neighborhood.
D. They cannot qualify to own property in a higher-priced area. Answer. V. Should any prospective purchaser enter your office requesting to see a particular property, you would assume they were interested in that particular property. Question 6. A subdivider and developer purchased considerable acreage and now plans to construct a tract of 40 homes. In arranging the financing for the new construction, the lender has agreed to advance part of the funds immediately and will release a set amount of additional money as each home is completed. The funds that will be forthcoming as construction progresses are known as A. Obligatory advances. B. Reconveyance funds. C. Release monies. D. Open and mortgage payments. Answer. A. This type of construction financing is referred to as obligatory advances or fixed disbursement schedule. Question 7. All of the statements below are true, except A. A grant deed may convey after acquired title even when such warranty is not actually written into the contents of the deed. B. A quitclaim deed may convey any right or title including fee simple title. C. A deed is of no effect unless delivered. D. A reconveyance deed is used to convey title to a new purchaser in connection with a trust deed sale. Answer. D. A reconveyance deed is given by a trustee to the borrower, known as the trustor, after a loan has been paid in full. The borrower records his deed of reconveyance to clear the loan lien from the record. Question 8. Which of the following is not a necessary element in the formation of a contract? A. Offer. B. Acceptance. C. Consideration. D. Performance. Answer. D. Two parties may enter into a contract, but they might not fulfill, also known as perform, their obligations. Question 9. Lenders use the term debt-income ratio to refer to A. Part of closing costs. B. Loan qualifying tool. C. Requirement of the federal government. D. Formula used in appraising property. Answer. B. Debt-income ratio indicates the fraction that your loan payment on the property is in relation to the net income from the property. This is used by lenders when qualifying a person for an income property loan and measuring their margin of safety. Question 10. A prospective client calls you and asks you to take a listing on his property. In reviewing his papers, you discover he is purchasing the property on a contract of sale that has no acceleration clause, and that has no provision in the contract prohibiting a resale or an assignment. Which of the following is the most nearly correct statement? Your client could A. Sell his interest in the property, but only if he pays off the contract first. B. Sell or assign his rights but not his duties under the original contract unless the contract seller's approval was obtained. C. Properly give the purchaser a warranty deed to the property providing the deed recited subject to the existing contract of sale. D. Properly give the purchaser a grant deed to the property, providing he took back a recorded purchase money second trust deed to cover the payments due on the original contract of sale. Answer. B. A party purchasing property under a land contract of sale may sell their interest without difficulty by assigning the contract, provided there is no prohibition on the agreement. The assignee would still be secondarily liable for some of the terms of the contract unless the seller's approval was obtained.
Passing the real estate exam can be hard, like really hard. Statistically, only about 50% of people actually pass the real estate exam on their first try. Those people that pass, they go on to become real estate agents. And the people that didn't pass, they either give up completely or have to try again. Both of these options are painful, disappointing, and upsetting. Exam Scholar Real Estate Edition has been named as the best real estate exam prep by multiple publications for 7 years in a row. If you are about to take the real estate exam, Exam Scholar Real Estate Edition is a no-brainer choice. There is no other real estate exam preparation service out there that comes close. To enjoy the longest membership time, lowest cost, real estate videos, audios, articles, flashcards, vocabulary, exam tips and tricks, a 1-year no questions asked refund policy, and be one of the 35,000 people that it has helped pass the real estate exam, then sign up in less than 5 minutes at www.realestateexamscholar.com.
Question 1. Under FHA standards, the minimum ceiling height for a single-family residential construction is A. 7.5 feet. B. 8 feet. C. 8.5 feet. D. 9 feet. Answer. A. Although most ceiling heights are 8 feet, the FHA minimum requirement is 7.5 feet. Question 2. Real estate assets are usually acquired by using A. The results of long-term and short-term gains. B. The supply and demand of equity capital. C. Equity funds and money market funds. D. Debt funds and equity funds. Answer. D. There are mutual funds and real estate investment trusts that do acquire real estate assets, either debt assets, mortgage assets, or equity assets, ownership assets. Question 3. From a historical standpoint, the major function, objective and aim of the FHA program has been provided by A. Title I. V. Title 2. C. Title 3. D. Title 4. Answer. B. The largest and most important activity of FHA is the insurance, under Title II, of mortgages for home purchase and construction. Question 4. Examples of negotiable instruments are as follows, except A. A mortgage secured by a promissory note. B. A draft. C. A check. D. An installment note. Answer. A. The note is negotiable but not the mortgage. Question 5. A form that is usually prepared to allow a real estate licensee to act as an agent for all principal parties to the transaction involved is A. An agreement of sale. B. An exchange agreement. C. A loan broker's statement. D. A real property security statement. Answer. B. Under an exchange agreement, the real estate licensee acts for both parties. This is one instance where he could earn a commission from each party to the transaction. Question 6. The hiring of a specialist in property management would be justified by A. Absentee ownership. B. Technological advances in building concepts. C. Vacancy factor higher than normal. D. Urbanization. Answer. A. In absentee ownership. The owner lives away from the property and is not able to adequately supervise it. Question 7. Which of the following is not one of the four important elements of value? A. Scarcity. B. Appreciation. C. Utility. D. Transferability. Answer. B. The four elements of value are utility, scarcity, demand, and transferability. Question 8. Madison is a mortgage loan broker. When setting up a loan, Madison differs from Carter, a mortgage banker, in which of the following ways? A. Carter is authorized by law to make larger loans than Madison. B. Madison is exempt from the Finance Code. C. Madison does not normally use his own funds in arranging a loan. D. Carter deals primarily in loans which must be recorded. Madison's loans are normally not recorded. Answer. C. A mortgage loan broker normally does not loan his own funds, but negotiates the placement or sale of a loan with a particular lender. A mortgage banker generally has the funds with which to make a loan. Question 9. The following are correct statements concerning an option, except A. The optioner must perform if the optionee exercises his option within the period specified. B. The optionee must perform if the optioner exercises his option within the period specified. C. To exercise the option, the buyer must pay the amount specified in the option. D. The consideration for granting the option must be actual. Answer. B. The question is a negative question asking for a false statement concerning options. Answer 2 states, the optionee must perform, which is false. The optionee receives and the optioner must perform. The optionee is the one who exercises the option. Answers 1, 3, and 4 are all correct. Regarding answer 2, there must be some consideration. It may be money or an act. In a lease option, it often states that there is the option to purchase the property for $100,000. The consideration is the leasing of the property. The leasing of the property is sufficient consideration upon the part of the optionee. An option must contain all the terms of the purchase similar to a deposit receipt. At the time of exercise, all that the optionee must do is state, I will buy according to the option terms. Question 10. The provision that states the realtor shall not publicly disparage the business practice of a competitor appears in the A. Real estate law. B. Commissioner's rules and regulations. C. NAR Code of Ethics. D. Business and Professions Codes. Answer. C. This provision appears in the National Association of Realtors Code of Ethics. Question 1. Which of the following best describes a complete escrow? A. It is considered a perfect escrow. B. The escrow holder has ceased being an agent for both parties. C. All papers are properly drawn up and ready for final steps to be taken to close the escrow. D. All services of the escrow holder are involved. Answer. C. The settlement in choice C describes a complete escrow. Usually an escrow is complete in the evening and closes the following morning when the deed is recorded. Question 2. When a legal description uses only sections, townships and ranges, the lines relate to the A. Government survey lines. B. Contour lines. C. Recorded tract map. D. Meets and bounds descriptions. Answer. A. Sections, townships and ranges are used in government surveys in describing the location of land. Meets and bounds description outlines a certain area. Question 3. A lender would be exempt from the requirement of providing the borrower with a federal right to rescind notice except A. If the loan is for more than $25,000 and is not secured by the borrower's personal residence. B. If security for the loan is commercial property.
C. If the loan is for business expansion.
D. If the borrower is refinancing. Answer. D. A negative question. Refinancing your personal residence is not an exemption and is fully covered by a 3-day right of rescission. Question 4. Fisk owns a lot. He also owns a right-of-way easement over the property of his neighbor, Smith. This easement is appurtenant to Fisk's lot. Fisk sells his lot to Jones without specific mention of the easement in the deed. The easement A. Remains with Fish as an encumbered interest. B. Passes to Jones. C. Terminates unless it is a covenant running with the land. D. Reverts to Smith. Answer. B. Appurtenant easements run with the land and automatically pass to future grantees, whether mentioned in the deed or not. Question 5. Which of the following would normally install conduit? A. Plumbers. B. Electricians. C. Roofers. D. Carpenters. Answer. B. Electrical wiring is placed inside a metal pipe called a conduit. Question 6. Two people entered into a land contract for the purchase of a home and the contract was recorded. A few months later, the vendee abandons the property and defaults on the contract. If the vendee refuses to execute and record some form of release, it will A. Not affect the marketability of the property. B. Result in a deficiency judgment. C. Result in a trustee's sale. D. Create a cloud on the title. Answer. D. A recorded land contract show an equitable interest in the property. When the vendee, buyer, defaults and abandons the property, the land contract becomes a cloud on the title until it is removed by either a quitclaim deed or a quiet title action. Question 7. A broker who is hired by an owner to sell his property must reveal all significant and material information to the principal. Which of the following would be considered material information and must be revealed? A. The new lender will require the buyer to maintain an impound account. B. Agent's knowledge that a better offer to purchase is imminent. C. The prospective buyer is of Oriental descent. D. None of the above. Answer. B. The existence of a better offer that is imminent could very well be a material fact to the seller. It would probably influence his decision on a present offer. Question 8. Generally, the most important determinant of a property's value is A. Age. B. Utility. C. Location. D. Income. Answer. C. Location is the most important factor influencing value, the other factors being utility, size, shape, thoroughfare conditions, exposure, character of the business climate, plottage or assemblage, character of the soil, grades, obsolescence, building restrictions and zones. Question 9. Real property includes the land, those things attached to the land, and thing called appurtenances. Appurtenances include all of the following except A. A dwelling. B. Trade fixtures. C. Watercourses. D. A fence. Answer. B. Trade fixtures are considered personal property. Question 10. How many acres are in the west half of the south half of the south half of the south half of section 27? A. 20 acres. B. 40 acres. C. 80 acres. D. 160 acres. Answer. B. Section 27 equals 640 acres. S half equals 320 acres. S half equals 160 acres. S half equals 80 acres. W half equals 40 acres. Question 1. During broker Shaw's preparation of the exclusive authorization and right to sell on seller Norman's property, Norman asked that a clause be included which would require the buyer to accept primary liability in connection with when the existing loan is transferred to the buyer. Shaw should enter which of the following in paragraph 2 of the exclusive authorization and right to sell? A. Buyer to take the property subject to the loan. B. Buyer to assume existing loan. C. Buyer to pay all cash. D. Buyer to make a large down payment to preclude possibility of a foreclosure. Answer. B. If a buyer assumes an existing loan, he accepts primary liability for that loan. Question 2. A third party who takes a promissory note that is complete and regular and has no knowledge of any defects is known as A. An endorser. B. A maker. C. A payee. D. Holder in due course. Answer. D. The party that accepts the endorsed note from the original payee without knowledge of any defects is known as the holder in due course. Question 3. The owner of a single-family residence plans to sell and wants to obtain an FHA appraisal to permit a sale with FHA financing. He should A. Contact the nearest FHA office for an appraisal of this property. B. Have a lender apply for a firm commitment. C. Have a lender apply for a conditional commitment. D. Submit a recent appraisal of his home to FHA. Answer. C. The recommended process for the lender to contact FHA for a conditional commitment, that is, for advance assurance that an FHA loan will be made, establishing the loan value for the house. Question 4. A buyer defaults in making payments on a loan, therefore the lender's action probably would result in A. Subordination. B. Escalation. C. Acceleration. D. Alienation. Answer. C. Acceleration indicates the right to declare the entire sum of a note to be due and payable immediately. Most trust deeds contain several acceleration clauses. Most common states, if you become delinquent in the payment on this note, the entire sum of the note becomes due and payable immediately. Other states, the entire sum of the note is due upon the sale or transfer of the property triggered by the sale of the property and therefore is a specific acceleration clause. The rule is, alienation clauses are types of acceleration clauses, but not all acceleration clauses are alienation clauses. Question 5. Which of the following is the classic definition of the boundaries of real property? A. A surface area indicated on a map. B. A reasonable use of airspace and extended to the center or the earth. C. A reasonable distance down and unlimited airspace. D. A practical or reasonable use of the earth and unlimited airspace. Answer. B. The surface of the earth and the material beneath the surface to the center of the earth is part of the real property. Since airways are now public domain, the ownership of airspace is used to an enjoyable and reasonable height. Question 6. A buyer defaults on a loan, therefore the lender would be able to cause the promissory note to become due and payable. This clause is A. A subordination clause. B. An escalator clause. C. An acceleration clause. D. An alienation clause. Answer. C. Acceleration clauses are several different types and reasons. Question 7. In general, when the supply of a certain commodity increases, A. Price tends to rise. B. Price tends to drop. C. Demand for it tends to rise. D. Demand for it tends to drop. Answer. B. If demand is constant and supply increases, sellers compete with each other by lowering prices. Question 8. An offer to purchase real property was signed by a prospective buyer on October 2, 1977. The terms of the offer allowed 5 days for acceptance by the seller. Because of an illness in the seller's family, the seller did not accept the offer until October 10, 1977. Which of the following statements is correct? A. The buyer may demand the return of his deposit. B. The buyer must continue with the purchase because he did not withdraw his offer prior to acceptance. C. If the buyer does not complete the purchase, the seller is entitled to the deposit. D. If the buyer does not complete the purchase, the seller and the broker will each be entitled to 1/2 of the deposit. Answer. A. This constitutes only an offer, and one method of terminating an offer is the expiration of a specified or reasonable length of time for the acceptance to be communicated. Question 9. An offer by one of the parties to a real estate transaction to carry out that party's part of the contract is called A. Gratuity. B. Satisfaction. C. Recourse. D. Tender. Answer. D. Usually made at the conclusion of the transaction, the tender is the offer to perform on the terms agreed to. If the other party cannot perform, then the party that made the tender can rightfully claim the other party defaulted. Question 10. Should a person be discriminated against, what would best describe the actions available to them? A. Private action in a state or federal court. B. Civil action in state superior court. C. Criminal action in a state court. D. Criminal action in a federal court. Answer. A. As discrimination is not a criminal act, we would eliminate answers 3 and 4. 2 is incorrect as the remedy available to the injured party is not limited to only action through a state court. It could take place through the federal courts. Question 1. Which of the following factors primarily affects supply in the real estate market? A. Population. B. Demographics. C. Employment. D. Government financial policies. Answer. D. Population, demographics and employment impact demand for a commodity, but government fiscal, spending and taxing policies strongly influence availability and cost of credit for those who produce things to be sold, like new homes. Question 2. Of the following, the method which allows the most depreciation to be taken during the first year would be A. Straight line method. B. 150% declining balance method. C. 200% declining balance method. D. Sum of the year's digits method. Answer. C. The 200% declining balance method of depreciation allows the most depreciation for the first year. The sum of the year's digits method allows the most depreciation in the earlier years. Question 3. Daniels purchased 60 acres of land near a city. He intended to subdivide it for sale as single-family residential lots and sell the lots for cash. Daniels needs maximum financing to put in streets, curbs, gutters, sidewalks, etc. He wants to pass the cost of these to the lot purchasers in such a way that when title policies are issued to future lot owners, the policies will contain no reference to assessment liens for the above stated purposes. Daniels' best course for financing these needs will probably be A. Real property sales contracts. B. Improvement bonds. C. Interim loans from institutional lenders. D. Corporate stock. Answer. C. Answer B would result in assessment liens. Answers A and D are not specifically financing means for such improvements. By elimination, answer C is the best choice. Question 4. A new well and pump were installed on a parcel of land. For property tax assessment purposes, the county assessor would consider these as A. Improvements. B. Additions. C. Part of the land. D. Personal property. Answer. A. A well and pump would be improvements to the real property. Question 5. Which of the following factors is most likely to influence demand for real estate? A. The number of real estate brokers in the area. B. The number of full-time real estate salespersons in the area. C. The wage levels and employment opportunities. D. The price of new homes being built in the area. Answer. C. When wage levels and job expansion are increasing, workers are more likely to buy real estate. When wages are stagnant or declining, they hold back from making big purchasing commitments. Effective demand requires not only the desire to purchase a product, but also the financial means to do so. Question 6. The one unity in a joint tenancy holding that is also present in tenancy and common holding is A. Equal right of possession. B. Right of survivorship. C. Equal interest of all owners. D. Tenant in possession can be charged rent for the use of the land. Answer. A. Under any type of ownership, each owner has an equal right of possession. This means that any owner can go anywhere on the property regardless of the percentage of their overall interest. Question 7. As a part of the purchase price, the seller of a parcel of land accepted a purchase money first trust deed which contained a subordinate clause. This clause would A. Guarantee priority of the first trust deed. B. Preclude the buyer from placing construction loans on the property. C. B. Permit the buyer to place a future loan on the property that would have priority. D. Permit additional liens to be placed against the property without the buyer's consent. Answer. C. A loan in a trust deed that contains a subordination clause supersedes the rule the first to record is the first in right. A subordination clause in a note and trust deed is evidence that the lender agrees that a future obtained trust deed may be prior to this loan even though the future loan is recorded later. Oftentimes builders use this clause in a trust deed and note used to purchase raw land from the owner. They offer the owner the full price contingent upon him carrying back financing for the land. The trust deed that he is to receive from the builder must contain a subordination clause in which the owner of the land agrees to be junior in priority to a future recorded construction loan. Question 8. Capitalization is an appraisal process used to A. Convert net income into market value. B. Establish book value. C. Determine net income. D. Establish a capitalization rate. Answer. A. Capitalization of income is a method of establishing the value of income-type properties. Question 9. The type of legal action that would most likely be taken in the event of a default on a land contract would be A. Lease pendens. B. Writ of execution. C. Foreclosure by trustee's sale. D. Quiet title action. Answer D. If the original land contract had been recorded and the buyer has defaulted, there would be a cloud on the title and some form of legal action would be required to clear the title. This would not be a foreclosure but a quiet title action. Question 10. A subordination clause in a trust deed may A. Give priority to liens subsequently recorded against the property. B. Allow for periodic renegotiation and adjustment in the terms of the obligation. C. Prohibit the trustor from making an additional loan against the property before the trust deed is paid off. D. Permit the obligation to be paid off ahead of schedule. Answer. A. A subordination clause written into a loan gives a lower, secondary position to that loan if another loan is recorded later.
Exam Scholar, Real Estate Edition.